If you have ever walked away from a crash thinking, "At least I'm alive," only to open the insurance company's first offer and feel sick, you are not imagining things. Most accident victims do get far less than they deserve, and it usually happens long before they realize a mistake has been made. It happens in the first phone call. It happens in the medical records. It happens when pain gets described as soreness, when missed work gets shrugged off, and when a serious disruption to your life gets reduced to a stack of bills and a quick signature. The truth is, insurance companies do not pay based on how unfair your situation feels. They pay based on what can be proven, what can be minimized, and what they think you do not know. So if you are hurt, overwhelmed, and trying to do the right thing, you are exactly the person most likely to get underpaid. In this video, you are going to learn why that happens, how the system really works, and what you can do to protect the full value of your case. I'm a practicing personal injury attorney, and I handle car wreck cases, truck crashes, slip and falls, and other injury claims every single day. I talk to people at the exact moment when they are hurt, stressed, missing work, and wondering whether the offer on the table is fair. And here is what I have seen over and over again. Good people with legitimate injuries routinely settle for far less than the law actually allows. By the end of this video, you will understand the 4 biggest reasons claims get undervalued, the mistakes that quietly weaken a case, and the practical steps you can take right now to stop leaving money, treatment, and leverage on the table. The first big reason most victims get underpaid is simple. The insurance company starts low on purpose, because the opening offer is not a measurement of what your case is worth. It is a test of how badly you need relief and how little information you have. In plain English, the adjuster is trying to close the file before the full picture develops. An adjuster is the insurance company employee who evaluates your claim and negotiates payment. Early on, they may not know how long your pain will last, whether you will need future treatment, how much work you will miss, or how your injuries will affect your daily life. But they do know one thing. If they can get you to settle now, they do not have to pay for what shows up later. Imagine you are driving home from work, another car runs a red light, and 2 days later your neck feels tight, your back is spasming, and you cannot sit through a full shift. Then the insurer calls and offers a few $1,000s, saying it seems reasonable because your car damage was minor and you were not taken away in an ambulance. What most people do wrong is they compare the offer to what is in front of them today. They think, maybe I can handle this. What the law actually cares about is the full extent of your damages, meaning your losses, not just the bill you already received. Until your treatment path is clear, the first number is usually just a discount offered in a calm voice. The second reason victims get shortchanged is that they think a claim is just math. They add up emergency room charges, the cost of physical therapy, maybe a few lost paychecks, and assume that total is the case. It is not. In most injury cases, the law allows recovery for economic damages and non-economic damages. Economic damages are the financial losses you can count, like treatment costs, wage loss, medication, transportation to appointments, and future care. Non-economic damages are the human losses that do not come with a receipt, like pain, sleep disruption, anxiety, loss of mobility, and the ways your injury steals normal parts of your life. Imagine you are a parent with a shoulder injury after a rear-end crash. Your medical bills might be $5,000. But what if you also cannot pick up your child, cannot sleep on one side, cannot work overtime, and cannot do the yard work you used to handle every weekend? Those losses are real, and the law often recognizes them, even though they are harder to prove. What most people do wrong is they talk about the bills and stay silent about the life impact. They tell the doctor, "I'm okay," because they do not want to complain. They tell the adjuster, "I'm getting by," because they want to sound reasonable. What you should do instead is describe your limitations honestly and specifically. The claim is not just about what happened to your bank account. It is about what happened to your body, your routine, your family role, and your peace of mind. The third reason claims lose value is documentation. Not because paperwork is exciting, but because the insurance company treats missing records, inconsistent complaints, and treatment gaps as proof that you were not really hurt. A treatment gap is simply a stretch of time when you stop getting recommended care. Sometimes there is a good reason. Maybe you could not get an appointment. Maybe you lost transportation. Maybe you thought you should tough it out. But if there is no clear explanation in the records, the insurer will often argue that you must have been feeling fine. Imagine you go to urgent care after a fall in a grocery store. Your knee swells, you limp for 2 weeks, and then you stop treatment because work gets busy. A month later, the pain flares up, an MRI shows a torn meniscus, and suddenly surgery is on the table. The insurance company will not focus on your pain. They will focus on the month you disappeared. They will say, if you were truly injured, why did you wait? What most people do wrong is assume the truth is obvious. They think photos, a crash report, or a diagnosis should be enough. But cases are built on consistent storytelling across medical records, employer records, witness statements, and your own words. What the law and the insurance process reward is credibility. That means reporting symptoms accurately, following through with care, and speaking up if something in the chart is wrong. If your doctor notes, say, mild discomfort when you have not slept in a week, that mistake can echo through your whole claim unless it gets corrected. The fourth reason victims get less than they deserve is that even a strong injury case can shrink if blame becomes contested. Liability is the legal word for who was at fault. And in many states, if the insurance company can stick some percentage of fault on you, your recovery can drop, sometimes dramatically. Imagine you are in a parking lot, another driver backs into you, and at first it seems obvious they caused the crash. Then the insurer says you were driving too fast for the area, you should have seen them sooner, or you failed to brake in time. Now the case is no longer just about injury, it is about percentages. If a jury or insurer decides you were 20% at fault, your compensation may be reduced by 20%. In some states, if you cross a certain threshold of fault, you can lose the right to recover anything at all. What most people do wrong is they casually fill in gaps for the other side. They apologize at the scene just to be polite. They speculate about what they could have done differently. They post online about being clumsy or probably fine. They give recorded statements before they understand the issues. A recorded statement is a formal interview the insurer may use later to lock in your words. What you should know is this: fault is a legal argument, not a gut feeling. You do not help your case by guessing, minimizing, or trying to sound fair to the person who hurt you. You help your case by sticking to facts, preserving evidence, taking photos, getting witness names, and understanding that even small comments can be turned into leverage against you later. Here is where things go wrong even for careful people. Most people do not realize that being honest is not the same as being complete. They tell the doctor the pain is not too bad because they are embarrassed, grateful, or trying to stay positive. Then weeks later, when the pain is worse, the insurance company points to that early note and says the later complaints must be exaggerated. You are not helping your case by being stoic. You are creating a record that understates what you are living with. Most people also do not realize that speed can be the enemy. They want closure. They want the bills handled. They want the calls to stop, so they accept a check before they know whether they will need injections, surgery, specialist care, or more time off work. Once a claim is settled, it is usually over. In most cases, you do not get to come back and ask for more because your recovery turned out to be harder than expected. And here's the third mistake that surprises almost everyone. They assume their own insurance company is automatically on their side. Sometimes it is, and sometimes it is still a business evaluating exposure, meaning how much money it may have to pay. If you have uninsured motorist coverage, medical payments coverage, or short-term disability involved, every conversation still matters. The language you use, the documents you provide, and the timing of your treatment can affect multiple claims at once. That is why a careless statement to one insurer can quietly damage another part of your case. The biggest trap is thinking the system will piece everything together for you. It will not. If you do not actively protect your claim, the gaps, shortcuts, and innocent little phrases can end up costing you far more than you ever expected. First, you need to get proper medical evaluation and follow the treatment plan unless a doctor changes it. If something hurts, say it clearly. If a symptom gets worse, report it. If you cannot afford care or cannot get scheduled quickly, document that problem so there is a reason for any delay. Second, keep your own simple case file. Save photos, prescriptions, bills, discharge papers, mileage to appointments, wage loss information, and a short journal of how the injury affects your sleep, movement, work, and family life. You do not need to write a novel. You just need a clear record of what this has actually cost you. Third, be careful with statements. Give necessary facts, but do not guess, speculate, or minimize. If an insurance adjuster wants a recorded statement, understand what is being asked and why before you agree. Casual language can become permanent evidence. Fourth, do not judge your case by property damage alone. A low-speed crash can still injure a person, especially if the force twists the neck, back, knee, or shoulder in a vulnerable way. Your body is not a bumper. And fifth, if the injuries are significant, the liability is disputed, or the insurer is pressuring you to settle quickly, talk to a qualified personal injury lawyer sooner rather than later. The goal is not to start a fight. The goal is to understand the value of your claim before you sign away your rights. One good conversation at the right time can prevent months of regret later. If you are dealing with an accident claim right now, I know this process can feel exhausting, confusing, and unfair, but educating yourself before you make a decision is one of the smartest things you can do. The more you understand how these cases are undervalued, the better you can protect yourself from getting rushed, minimized, or pushed into a bad settlement. If you have questions, drop them in the comments, because chances are someone else is dealing with the same issue. If you want plain English legal education like this every week, subscribe to the channel. And if you have a specific situation and need advice tailored to your facts, reach out for a consultation. You do not have to figure this out alone, and you do not have to settle for less just because the insurance company hopes you will.